So good afternoon, everyone. My name is Martin Phillipson, and I'm the Dean of the University of Saskatchewan's College of Law. And I'm pleased to welcome you to this virtual speakers event presented as part of the McKercher LLP lecture series at the College of Law. As we gather here today, I acknowledge that I am on Treaty 6 territory and the homeland of the Métis people, and we pay our respect to the First Nation and Métis ancestors of this place, and we reaffirm our relationship with one another. This edition of the McKercher LLP lecture series at the College of Law is being presented entirely online. And while we may not be able to gather in a physical space, we have been more committed than ever this year to delivering a wide range of informative, educational, and entertaining speakers to the law school community and beyond. Before we begin, I want to go over a couple of online housekeeping matters. First of all, please note that the lecture is being recorded and will be available online afterwards. And secondly, we ask that during the lecture, you mute your microphones and turn off your video to help with the quality of the virtual connection. So if you keep your microphones muted to avoid feedback and turn off your video. If you have any technical issues, please comment in the chat window and our College of Law staff will do their best to assist you. I do want to take a brief moment to thank McKercher LLP for their continued support of this lecture series and for their ongoing support of the college. I now would like to introduce President Peter Stoichkov to say some words of welcome to our speaker today.
Well, thank you, Martin, and thank you to the almost 200 people and counting who are joining us today. And it's my distinct pleasure to introduce to you formally, as she deserves, our next guest speaker in the McKercher Lecture Series, the Honorable Rosalie Silberman Abella, Justice of the Supreme Court of Canada, and whom my wife Catherine and I are proud to call a friend. Justice Abella was a friend of my father's, and she generously and luckily transferred that relationship to us. Justice Abella was appointed to the Supreme Court of Canada in 2004, becoming the first Jewish woman appointed to the country's highest court. She was elected to the Royal Society of Canada in 1997 and to the American Academy of Arts and Sciences in 2007, and welcomed by the American Philosophical Society in 2018. In 2020, she was honored by the prestigious Knight Commander's Cross of the Order of Merit by the President of Germany. Justice Abella attended the University of Toronto, where she earned both her Bachelor of Arts degree in 1967 and Bachelor of Laws in 1970. In addition to her love of law, she also has a passion for the arts, graduating from the Royal Conservatory of Music and Classical Piano in 1964. Justice Abella's legal career began in 1972 when she was officially called to the bar in Ontario and practiced civil and criminal litigation until 1976, when she was appointed to the Ontario Family Court at the age of 29, becoming the first pregnant person appointed to the judiciary in Canada. After serving family court for 16 years, Justice Abella was appointed to the Ontario Court of Appeal in 1992 and joined the Supreme Court of Canada 12 years later in 2004. Throughout that time, she has also remained involved in and dedicated to Canadian judicial education as a staunch supporter and advocate for teaching those both inside and outside the legal profession. Over the course of her remarkable life in law, Justice Abella has received numerous honors and awards over the years, including no fewer than 39 honorary degrees. A recipient of the Distinguished Service Award of the Canadian Bar Association in Ontario, Justice Abella has also written more than 90 articles and has written or co-edited 4 books during her distinguished career. In a memorable recent piece in the Globe on Ruth Bader Ginsburg, Justice Abella called her incandescent, and I'd say the same of Justice Abella. In fact, much of what Justice Abella said of Justice Ginsburg in that piece can be said of her. She represented the aspirations of a new generation of women in the 1970s and carried that message into the Supreme Court and developed it into a wider embrace of human rights. She coaxed the law into an understanding that women had the same right to the status quo's choices as men. Then she changed the status quo. Those are just a few of the highlights, achievements, and accomplishments of Justice Abella's remarkable career in law, and we are so fortunate to have the opportunity to hear from her today. I now return things to you, Martin, to begin today's conversation. And thank you, Justice Abella, for joining us.
Thank you, President Stoichev, and good afternoon again, everyone. If I could just remind you all to mute and to switch off your video. I want to say thank you to Justice Abella for agreeing to come back to the College of Law. She gave the Law Review lecture in 1999 and also has had other visits to the school, so we're delighted to welcome her back in this, her final year as a sitting Justice of the Supreme Court. When I approached Justice Abella, we discussed the format, and often Supreme Court judges will come and give a prepared speech, but Justice Abella thought it would be more interesting and engaging to do a Q&A with the law school community. So we sent out a request to our students for questions for Justice Abella, and so we will base our conversation around some of those questions today. So I'm going to start with an easy one. 10 years ago, Chief Justice McLaughlin raised concerns about access to justice and the barriers to judicial review for all but the wealthiest members of society. As the gap between the haves and the have-not grows, it is becoming increasingly challenging, if not impossible, for individuals to seek justice through the civil system. With the growing awareness that these economic inequalities disproportionately impact Indigenous people, visible minorities, and women, it becomes apparent that vulnerable groups will inherently have less access to justice. What do you see as the role of the legal community, and especially new lawyers, in facilitating access to justice for vulnerable groups? As I said, a nice easy one to start with.
Right, the whole access to justice system. Perfect. What are the complicated questions? Well, let me first of all thank you, Martin, for inviting me back to the law school. I'm so grateful to have the chance to come back. I was hoping that it would be in person, but nothing is happening in person these days. So you've kept us safe, but you've also given me a chance to reach out to this community that I feel such affection for, and always have. And thank you to the president, Peter and Catherine. I've been so lucky in the people that I've had a chance to meet over the last 50 years since I graduated from law school. And two of my favorites are Peter and Catherine. I think University of Saskatchewan is very lucky to have them in the leadership role. And my husband and I feel very lucky to have them as friends. Although I have to say, Peter, the sound that I was friends with your father made me realize how old I really am. But I did love him, and I love his son and his son's wife. So thank you for that. Okay, access to justice. I think this is the biggest challenge facing the legal community, and I think it is our biggest responsibility to fix. I have never understood how the legal system thinks access to justice has meant tinkering around the edges of reform. I mean, if we're really serious about access to justice, I think we have to remember that in 1906, Roscoe Pound, who was Dean Harvard Law School, gave a speech to the American Bar Association, 1906, criticizing the American civil justice system for being overly adversarial, too complicated, too businesslike, too adversarial, and too procedurally focused. 1906. If you think about how medicine has evolved since 1906, how everything has evolved since 1906, including the role of women, by the way, since you've mentioned it, the role of Indigenous communities, the role of minorities, the role of persons with disabilities. Everything has changed except how we do civil trials. So I find it astonishing that you could really take a lawyer from 1906, give him, because it would have been him, a couple of hours of instruction, and he'd feel perfectly at home in our courtroom. I just can't imagine that with any other profession. So if the medical profession hasn't been afraid of fundamental reform in how it's saved, how can we say you can't tinker too much with justice in order to find ways to improve it? So the system works pretty well for judges, for some lawyers, although I think it's a very tough time for many lawyers too. It's not working for the public, and it hasn't worked for the public forever. And they're going to be like the Character Network one day and say they're just not going to take it anymore. And I can't blame them. because offering the mediation and arbitration isn't a solution. What we have never done in this profession, and I put it out as a challenge to your students, because it's going to have to come from the next generation that isn't locked into the status quo the way my generation is. Sit down. How would you design a system of dispute resolution? Forget what we've got now. What would you do starting from the ground up? Do you need judges on every case? Do you need 2 layers of appeal on every case? We're talking civil cases here on every case. People want their day in court. They don't want their years in court. And they want to know quickly who is going to have custody. Was their employment wrongfully turned away? Is their accident compensable? It's no satisfaction, I think, to them. Bank account drained several years later to say, I got the best Cadillac procedure ever. They want to know how the dispute should end. And they are not enchanted by the things we cling to, the procedural rafts we cling to that say this is justice. It's not. If you can't get to a dispute resolution, there's no point. It says, Gertrude Stein said, there's no there if you can't get there. So I respect everyone who has tried, but they've tried given the existing, and they've tinkered, really tinkered. And everything we've done, like mediation and arbitration, turns out to replicate the catechism that we had in the courtroom, because that's what lawyers are comfortable in. So, do you know the light bulb joke about lawyers? You know the light bulb jokes. How many does it take to change? You know what the light bulb joke is about lawyers? How many lawyers does it take to change a light bulb? Change. So we just have to be brave and understand that the system, as that excellent question points out, is not working for the people for whom the system exists.
So a supplemental then is, where does the impetus for change come from?
Well, I think it comes from the legal profession. I would like to see, it's not going to have legitimacy with the public unless the legal profession and the judicial profession is involved. But the judicial profession, I think, has, with respect, an important leadership role to play in supporting change. But I think the main drive has to come from the lawyers who will accept responsibility for helping to design a system that works for their clients, really works for their ordinary clients with ordinary bank accounts and ordinary disputes. And of course the judges will be involved and they will cooperate. But what you don't want is something that is allergic to change and that accepts premises that have been existing for over 100 years and weren't even working 100 years ago. So we've streamlined nothing as far as I'm concerned. I know there are projects across the country that are very good, but on the whole, I lay it at our feet, the legal profession's feet, to change. And with government and with academics. We need scholarship, but we need mostly practical input on designing something, really something new, without having in our heads the way we've always done it. That is not a valid rebuttal to the public. We've always done it this way. So just think in our heads about how medicine has changed since 1906. Roscoe Pound wrote that. We were using leeches. And look at medicine today. I mean, even during COVID, look at medicine today. And the legal profession at least has said, well, now we've got COVID, let's try technology. Will those reforms stick? I don't know. But we need to be committed to genuine reform in this profession. So all members of the profession, public service, academic, legal, and judicial, have to come together to speak to the public and say, maybe a royal commission, I don't know. something that really gets at the problem, but not a 5-year royal commission, because we've done all of the background. A quick one. Martin, what about you? Why don't you do it?
Well, as a self-regulating profession, the bar does have the ability to move these changes forward. So I think it is interesting that the bar can actually move things forward. And the danger for the bar, I think, is that if they don't do it, governments will do it for them at some point.
And they've been threatening to do it for a long time because they are hearing from the public what we don't seem to listen to. And the public doesn't really have access to us institutionally, do they?
No,
so
if you look at what's going on in British Columbia, with their online dispute resolution tribunal, I think, where you have satisfaction rates of 90-something% of people involved in that process, whereas the satisfaction rates of even people who win at civil trials is in the 10, 15, 20%, because they're usually bankrupt by the time it's finished.
Exactly.
And it's a Pyrrhic victory. So, and also in BC, they have produced a report last year where they're going to significantly regulate a lot of the healthcare professions and take away self-care regulation. And in the past couple of weeks, the BC Law Society has put out a report on this because they are worried that they will lose the ability to self-regulate if they don't change the way they run themselves. So I think there's a social imperative for the legal profession to actually do this, but I think there's also a pretty self-preservation imperative that the bar has to think about ways that people get access to justice, because again, otherwise governments will do it for them. Excellent. So another question on another topic that's close to your heart. There are still a significant number of female lawyers who leave the profession very early on in their careers. And with the requirement that a lawyer serve 10 years at the bar before they're eligible for the bench, it eliminates a lot of the opportunities for women to become judges and to take part in the judicial process. So what are the barriers, and why do women still drop out at significant rates? And what can the legal profession and law firms do about that to preserve? Because now every law school in Canada is more than 50% women in terms of students. That's long since passed as an issue. But yet, if you look at the roles of the bar in most provinces for people who are 10-year plus calls, it's not 50% women. So can you give us some thoughts on how we go about fixing it? We've been talking about this for decades and decades and decades.
So this, Martin, is exactly what I was going to point out. These first two topics, both of which are excellent, just prove my point. We've always done it this way. Change. I mean, this was a hot topic in the 80s. After we started getting more women into the law schools. I graduated with 5 women out of 150, and the call to the bar was 15 women out of 520. And then the numbers really exploded, which was wonderful to see. And then they started dropping out because although the suggestion was, of course you can be a lawyer like everybody else, there were few accommodations made to recognize the realities, the life realities that most women experience if they decide that they are going to have children. And the ignoring of that, I think, came for 2 reasons. One, because there were women who were prepared to live with the requirements of particular law firms. And so they didn't have to really accommodate. Because law societies were quite deferential to law firms, since they themselves are the law firms, in what was required. The tenure track position, the partner track position is very competitive. Why should she get it if I'm there 18 hours a day and she wants to go home to take care of her children? So there are implicit barriers, which is why you see things like, what is work-life balance? I mean, those are the phrases that are out there for these women to grasp onto. You are entitled to work-life balance. You can lean in and lean out and lean up and lean down and all of that stuff. It's not true. There is no such thing as work-life balance. It's a myth that they are clinging to that makes them depressed when they can't do it, because of course they can't do it. It's impossible. So what are the solutions? Well, and by the way, I think quite a few men drop out because they find that the work imperatives, and there's no avoiding I can tell you, as someone who worked all the time with children, with in private practice and as a judge, you can do that if you have the ability financially to afford care for your children. If your children are if you're lucky enough to have children who are healthy, if you are lucky enough, as I've been, to have a husband who's an academic and wants to be home when the kids come home because I couldn't be, that's luck. I used to get requests from the press all the time saying, we would like to do a story on you. You've become a judge at the age of 29. You have 2 little kids. Can you tell us how you manage? And I said to them, I will not give you that interview because I am not a metaphor for anything. I am a metaphor for being lucky in life so far. Why don't you interview the women who can't afford a housekeeper, who get up at 5 a.m. to drag their kids to a child care place an hour away, do it at the end of their underpaid work day, come home and then do a full domestic load. Interview them. They're the real heroes. But if when I'm 75, I've got a husband who still likes me and nice kids, maybe I'll give you an interview. But I'm not going to be the place card for what works because I'm not typical. Everybody's got to work on their own. So what's the solution? It's not role models. The solution is business, law as a business, being smart about holding on to talent. And it isn't the 10-year rule. The problem is taking a long view. I mean, I became a judge after 4 years because they were desperate for women judges. I don't think I was particularly, oh my God, we really have to have her on a bench. She's only had 4 years, but she'll learn. So I was determined, knowing there were no other women on the family court bench, I had to do it really well, or they'd never hire a woman again. So, I felt that pressure and I was going to work really hard. But I saw so many really smart women leaving because they couldn't be who they wanted to be as parents, as spouses, as people with parents they wanted to look after, with other responsibilities, and still be brilliant humanist lawyers. They just weren't allowed to do it. And I didn't understand then, 40 years ago, why the profession wasn't opening up to them, and I don't understand it now. It makes good business sense. Do you know when Ronald Reagan tried to get rid of affirmative action in the United States in 1986? You know who came to him and said, don't do this, this works. It made us more sensitive to human resources. Business. The Organization of Employers in the United States said, we are now concentrating on how we are introducing more women and minorities into the workplace. They wanted him to keep it. We need that. We need to know that we are unhappily losing talent. No profession can afford to lose talent of any gender. So it's important to be aggressive about this and not be self-conscious and say, what about the merit system? That isn't necessarily what we've had until now. And introducing more people into the system who should have been among the old people in the system isn't reverse discrimination, it's reversing discrimination. So it's got to be an attitude change, and it's got to be an aggressive commitment to making sure you hold on to the talented people. And by the way, outside of the profession, why don't we have childcare? How can you ignore the reality that in most homes it is women who are responsible for domestic chores, and then say, but to do it, figure out a way to make it work? We have no excuse for not making the one thing most women need to be able to have a career or work and have families, which we want, most women want. It's childcare. And it's dangled in front of those women who can't afford housekeepers. as a one day we'll do this. It's like school. It's like education. It's like healthcare. It's crucial. We cannot survive without making sure there's quality childcare for children, not for mothers, for children. Otherwise, I have no opinion on the subject, Martin.
I think it's really interesting that the diversity question, it's deeper than that, because even if you do push more women, more minorities, more others into these positions, but the culture is completely unreceptive, they still drop out. So I think it's a deep cultural issue that we have to address both as a society and as a profession, as to how we make sure. But I think the business case, if you don't believe in anything else, the business case is actually crucial. So another excellent answer. Let's move on to a different question. I want to ask some different types of questions. If you could recommend to law students one thing to read, anything, a treatise, a book, a novel, a poem, the label on a shampoo bottle, anything, what would you recommend that they read?
That's a great question. These are great questions. What would I recommend? Oh, I would recommend that they read. So I can tell you what reading has meant for me. When we came to Canada in 1950, there was a library about 10 minutes away, public library. And my mother told my sister and I, every week, you go to the library, you bring home 3 books, read them, and then go back and get the next 3. So every Friday after when school was over, my sister and I walked to the Dufferin Street Library in Toronto and got 3 books. And I loved, it turned out that I really loved reading. And by the time I was 12, I finished all of the books in the children's section. But you couldn't be in the adult section until you were 14. But so they sent me over to the adult section anyway, because there was nothing else to read. And I wandered around, I found a book, I brought it to the librarian, and she said, you can't take this one out until you're 14. So I remembered the name of the book, because I thought, what is there in here that she doesn't want me to read? So as soon as I was 14, I got the book. It was called The Enemy Camp by Jerome Weidman. Why do I remember that? And I found the page where the scene that she didn't want me to read was, because it was for adults. Anyway, and then I worked my way through the adult section. It wasn't just that I loved reading. I discovered what injustice means by reading. Even though we were a Holocaust survivors' home, it was a very happy home. There were no demons. They were very encouraging, my parents. They were very supportive. The dark side of their experiences was never mentioned. So I have to say that until I was about 12 or 13, I didn't realize that there was injustice in the world, because my world was fine. It was middle class, but it was very loving. We weren't rich, but I didn't know what that meant even. And then I read Les Miserables by Victor Hugo when I was 13. I read a lot of big books. I went through the 19th century French writers, the 19th century Russian writers. Only because I had time, because Saturday nights were free, since I didn't seem to get asked out much. But that's okay. I'm not complaining. It's fine. So what did I discover in Les Miserables? I discovered that somebody was sent to jail for 19 years for stealing a loaf of bread, and some juice inside me just flowed through me. And I suddenly realized that this was injustice. And now reading Dostoevsky and reading Balzac, reading those books in English, I have to say, taught me what the world was like. And those novels became my instructive tutors on what the human universals were. So by the time I got to law school, I understood that there was a world that was different from mine, that it wasn't as fortunate as mine, and that it was my job as a lawyer to always have in my head their vulnerability and not my worldview. So I learned through clients, and then certainly as a family court judge, to understand the world from their perspective because of the novels I read. Rather than doing the top-down, judging what would I do in their shoes, that's not the question. Question is, What does the world feel like to them? So since then, I discovered magazines. I love magazines. I subscribe to many of them. I'm down to the New Yorker, Atlantic. I canceled Fair because it went off the rails for me after Graydon Carter left. Just didn't like it very much anymore. I read newspapers, Canadian and a couple of American ones, because I want to know what's going on in the world. I don't know how to use a computer. So everything is I have to have it in my hand. Now, this is a drag on trips, because if you're going on a vacation and you've got a suitcase full of books, that's really heavy. So people have Kindles. But I find reading, whatever you decide to read, make sure that it teaches you perspective. And by that, I'm not on social media. I don't know what people are learning, but I watch what goes on in the United States. And I realize that what people are reading is polarizing a whole society. So I can't tell you what not to read, but I think if you're careful about where your emphasis is, and there's nothing wrong with seeing what the rest of the world thinks. I mean, we can't live in silo. We need to know how the other side thinks about the world so we can think about why and maybe addressing it. But I think reading quality. I've graduated into biographies. I have seemed to have lost a lot of patience for novels. I read the Giller nominees every year, the final. But I like biographies. I want to hear how people became who they were. I find that so interesting. But I'm never without a book. Never without a book. And when I retire, I'm going to have time to read them, I think. So choose what you want to read, but read quality.
Do you have a favorite?
I have a bunch of books that I love. I love A Man Without Qualities. I love Mephisto by Mann. I loved Invisible Man by Ralph Ellison. I love everything by Margaret Atwood. I loved everything by Iris Murdoch and Margaret Drabble until the end of their careers. My favorites remain classics. The modern ones are John Updike. Do you really want to go through this? Malamed, didn't like Bellow. But Flaubert, Balzac, Zola, Gogol, Tolstoy. I'm trying to think of the writers that influenced me. Oh my gosh, so many. I'm not good on the South African or South American ones, but I don't have an absolute indispensable favorite, but I have Cakes and Ale by Somerset Maugham. Love Somerset Maugham. All of his short stories. So we can do this as a separate call one day.
Yeah, and I would like to point out that this wasn't planned by our English professor president either, so he didn't put this question on the agenda. I would go with Somerset Maugham and Iris Murdoch. We'll move on. This is a question for our 1Ls. We have a lot of 1Ls in the crowd of 338 people who will be doing their moots next week, their first moots. And I think they'd like a little bit of advice from you on oral advocacy and any golden rules that you have for successful oral advocacy. I'm sure they'd be delighted to hear from you. You see some of the best oral advocates in Canada in front of you on a regular basis, and some not so good ones. So I would be interested to hear from you, and they would be about what you would say are the 2 or 3 things they should do or not.
I think the most important thing to do is to bring yourself to comfort. I will never forget the mood I did in law school. I don't think disaster begins to cover it. I was so nervous. And when I look back on it, I think it's because I wasn't prepared enough. I just wasn't prepared. So number 1 rule, the best lawyers in the courtroom I have seen over 45 years are the ones who are prepared, who know their case, know how to tell a story, because advocacy is a narrative. And that's written as well as oral, because by the time you get to the appellate courts, like ours and the courts of appeal, we have incredibly wonderful judges in this country, and they prepare for court. So they walk into the courtroom having read your advocacy on paper. Sorry, paper, what can I say? Having read your words first, so they have in their head an idea of what the case is about and whether you've even preliminarily started to persuade them. So tell the story of your case the way it would persuade you. And then when you get in front of a judge, be prepared to understand that the judge may not have the same view of the case as you. So you need to be able to answer the questions he or she is going to ask you that go against the grain. So preparation of the facts, but also preparation of the law, because they will throw cases at you and say, but what about the 1984 decision of this court when we said? So you'll need to learn how to fudge elegantly, but you'll also need to learn not to be flustered, because most of the time judges are not asking you to be cute or to throw you off. They really want to know what you're trying to say. So the biggest trick, the biggest thing that has helped me learn to be a speaker, which is what advocacy is to understand what message I'm trying to give and have the confidence, develop the confidence to be able to do it as well as I can. Here's the other thing you need to know as one else. The fact that you lose doesn't necessarily mean that you were not a good advocate or that the other side was a better advocate. Sometimes the law wins for someone, or the facts win for someone, or the judges will think, is this a wise precedent to be setting? So do not take it personally when a judge asks you a question you don't know the answer to, or you find you haven't won. And clients need to understand that too. Sometimes it's just the way the court is leaning. And as you can see from our court, where it's rare to find a unanimous decision these days, there are different points of view about what a case really is about. So be sure of yourself. Be sure that you know as much as you need to know to be able to feel comfortable and confident, and then tell your story. Polite, no sarcasm, no smart alecky. I mean, these are just basic things. I mean, that doesn't go over. But a dignified presentation, quiet confidence is always impressive.
Thank you. We're having some audio issues. We're aware of it. We're trying to fix it. I think as long as just Isabella my questions, I think we're okay. Can you still understand my questions when I ask them?
I can.
You've answered them pretty well so far. So there was a question about what advice would you give to law students navigating technology through the pandemic, but I think we'll skip that one. I think you've indicated that wouldn't.
See this? This is my technology. This is what I write every decision, lecture, and speech with. A pen. I'm terrified of technology. Anyway, that doesn't mean I don't respect it, and I've written some very, very interesting technology judgments for the court, because as you will know, no judge knows everything. And before I hear a case, I know as much about the case as I hope the lawyers do. So I've learned a lot about technology in hearing cases, preparing for them, and writing decisions. But I'm still a person who writes by hand, so I have no suggestions for how to deal with technology.
So let's ask another COVID-related question. Which legal issues do you think COVID will raise that will end up at the Supreme Court of Canada?
Once I'm gone.
Yes.
Well, privacy. What does emergency mean? I think those are probably two of the big ones. And what it will test, I think, is the proportionality principle. And one of the great gifts, I think, of Canada to the world is its Section 1 jurisprudence. And for those who haven't had constitutional law yet, the section of the Charter which says all rights are guaranteed subject to reasonable limitations in a free and democratic society. So when you have something like a pandemic and measures being applied by government, the question will be, as it always is in these kinds of cases, was the restriction justified in a free and democratic society because the benefits outweighed the harms, the proportionality analysis. So other than, well, what do you think? Other than privacy and emergency health measures?
Sprang to mind were freedom of religion issues. There's a lot of issues with religious groups not abiding or thinking they shouldn't have to abide by public health orders. Also issues of mandatory vaccinations and employers perhaps making vaccination mandatory. Work at a workplace, that's already a question that's being bandied about whether or not employers will be able to mandate it. I know there's a lot of healthcare workers who may well refuse to actually be inoculated. And there's some questions there. So I think I'd be interested in mandatory vaccination and also interested in freedom of religion. I
think you're right. I think those issues will come up. They do in all of our rights cases. The very first case I heard at the Supreme Court was the same-sex marriage reference. And of course, those issues came up. You cannot impose this right on us because it offends our freedom of religion. And that's come up again and again, and will continue to come up. And the court will have to balance between the public good, the government says is the objective, and the harm that would be caused, because none of our rights are absolute. I mean, that's the beauty of the Charter. None of our rights are absolute. And I think that's mostly if you look at our freedom of expression jurisprudence, it's what divides us from the Americans in constitutional law, because we don't have that absolutist fervor for anything. We have a commitment and we respect those rights, but there's a balancing act.
What's the most important decision you think you wrote in your time on the Supreme Court?
You know what, we are having echoed chamber issues. Do you mind repeating the question, Martin?
What was the most important decision you think you've written in your time on the Supreme Court?
Oh, you're asking me to choose which of my children is my favorite. Isn't that a no-go zone? Well, I'm not being a Pollyanna when I tell you. I mean, I write 20, 30, 40 drafts of every decision that I write. Dissent, concurring opinion, majority. And that's the pen again. I edit myself, each draft. I look at it with fresh eyes. I don't circulate it, let alone release it, until it feels like something I feel proud of and stand behind. So I know some of them have had more impact than others, and I'm really grateful for that. In international law, in copyright law, in constitutional law and administrative law, used to have influence in administrative law, labor law, but every single one of them, because every career is like a Lego set, you know. It doesn't come into full view until all the pieces have been put together. And when I look at each one of those pieces was important to today, to where I am and what I've done by the time I graduate. So I can't take any one of them out and say, well, that was the one that I feel was the most important. I think there will be a lot of comment as the years go by, and time will prove which of them have turned out to be more important. But I've always done things on the understanding that it's not the moment that will judge you. It is time. It's the test of time. And so I'll see. Some of the things I wrote on the family court have turned out to be, like 100 years ago, have turned out to have resonance as time has gone on. The Royal Commission report was 35 years ago on employment equity. It's still floating around. Other things that I've written that I thought were terrific may turn out to be of no particular relevance or overtaken by new approaches, new philosophies, new judges, and that's fine. That's really the way the world works. And I'm just grateful for what I've had a chance to do and try to contribute. And I will say this to your law students, I mean, since so many of them are 1Ls. One of the main things that has helped me do what I've done in the career, ending with the Supreme Court, including decisions, is that I never, ever stopped to say, how will this affect my ability to get to be a X? So writing the first gay rights decision on the Court of Appeal, it never occurred to me to say, be careful, this is really controversial. You may never end up in the Supreme Court if you write these decisions. I never had next in my head. And so I was free to have a career that kind of took whatever came along. It was, there's a famous songwriter, Sammy Kahn, Tin Pan Alley songwriter. Somebody said to him, what came first, the words or the music? He said, the phone call. So that's my career. I never said I want to be a Supreme Court judge one day and measured everything I did towards the possibility of that happening. I just did whatever they asked me to do that seemed like an interesting thing to do in the legal profession. So same with judgments. I wrote the judgments that I felt strongly about because the world is not waiting for my views on everything. And some of them have proven to have more tentacles than others, but that's not my job. It's like the Royal Commission. It wasn't for me to say this is how it should be implemented. It was for me to put out the product and then leave it to others to decide what influence it would or wouldn't have.
It's interesting you answered another question, which was what led you to become a Supreme Court justice. But the second part of the question was, what do you enjoy about that position the most? What's the most fun thing about being a Supreme Court Canada judge?
Oh my God, I wouldn't even know where to begin. I have loved my colleagues. I have loved the chance to think about some of the most complex, sophisticated legal issues in the country. I've loved the chance that it's given me to meet with lawyers and judges and academics from around the world and learn from them. I've loved the chance, even on the 17 years that I've been there, to watch the law develop and to have played a part, sometimes more, sometimes less, in some of it. But mostly it's a front row seat on setting the parameters of what you think justice means for a country. I mean, what a privilege. Privilege isn't a word I use easily these days anymore, but to be able to see, and there's no, I'm not one of those people who say, oh my God, you really shouldn't say you make law, you're a judge. We do make law. I mean, it just makes no sense to me to say judges should only interpret, not make law. Of course they make law. When you interpret, you make law. The Persons case in 1929 said women were persons. That was interpreting the word persons. It made law. So the chance to make law, which sets at the legal level anyway, because the government, of course, has a prime role in deciding policy, but the chance to decide whether or not the government, the state, which gave the court responsibility through the charter to ensure constitutional compliance, the chance to think about whether or not those values have been properly implemented in a policy or law is the chance to help create an aspirational values environment. Brian Dixon said that the judges were the guardians of the Constitution, but that also means we're the guardians of the values of the Constitution. And I think the values that he and Bertha Wilson in that first decade laid out, which are still mine, unabashedly, you can tell from how many times I quote them in my decisions, made Canada a world leader in constitutional adjudication. We are now followed everywhere because of them and because of how they launched the thinking about the Charter. So I have loved the chance to participate in that process they started, and many of my colleagues since have carried on and help make Canada a leader in multiculturalism, rights development, rights protection, human rights, aside from all the black letter areas of law that we have contributed to. So that's been extraordinary. I never felt I had a role that wasn't important, I should tell you. Family court, as a mother of two babies, two little kids, deciding every day whether to take other people's children away. Hardest judging job I ever had, but it taught me how to be a judge. I thought that was really important. The profession had a hierarchical view. People said, don't take the family court. That's the lowest court in the country. Why would you do that? One day you could be on a federally appointed trial judge, for goodness sake. But what did I care? This was a chance to be a judge. And because I had no next in mind, I never thought about it otherwise. But it was really important to every person who was in front of me, making those decisions. So now I'm on at a differently important, much bigger canvas than I had before. And that's been the most fun, to think about what would be best for Canada, for justice in Canada, with 8 smart people. Pretty great.
So I take it you would have extra time for the phrase judicial activism, which I think is thrown out as an epithet these days.
Oh, I remember seeing, it was really interesting because I started hearing it. We started hearing it in Canada in the 90s. We'd never heard it before because in the 80s, during the Dixon-Wilson, and I call them, as you may have heard, the Fred and Ginger of the Charter because they choreographed it so beautifully. And everybody cheered at the routines they developed. I didn't start hearing the phrase until the 90s. The court changed and became much more focused on the rights of the accused. Who the judges are makes a difference. It was the Lemaire court rather than the Dixon court, and it was very important in developing the rights of the accused, but it didn't resonate quite as happily with the public. And we had started to talk about gay rights, and that, of course, the combination of the accused focus with people who were upset about the encouraging gay rights, and different political environments, Margaret Thatcher, the world had changed, and different press, scrutiny, different philosophies of the press. So suddenly, words that I had never heard before, like politicization of the judiciary and judicial activism, came in, and they were stolen from the United States, because at the time, people like Orrin Hatch and Tom DeLay, the exterminator from Texas, kept talking about judicial activism. And it was clear to me, so I started going across the country as a Court of Appeal judge to say, this is a misplaced version of what judges do. Judicial activism, if you translate it, is coming from a certain spectrum, certain aspect, certain part of the political spectrum, and it is designed to interfere with and presumptively rebut decisions that they don't agree with. That's really all it is. What does it mean for a judge to be active? What they mean is politicization. Similarly, we don't agree with your decision. So if we call it something that makes the public lose respect for what you're doing, and say you're really just, politicians in black robes, well, that works with a lot of people, and it worked in Canada for a while, and it's offensive. because it's a disrespect to what judges in Canada do and have always done. And that is their job. And when you do your job properly, it's going to be controversial. You're going to annoy some people. You're going to please other people. But we're not there to please anybody. And what does public opinion mean anyway? In Edith Wharton's book, Age of Innocence, there was a Mrs. Manson Mingott. Remember? Read the book? She was the social arbiter for New York. She said, okay, well, judges don't have that. And public opinion isn't evidence, and it can't be cross-examined. So we have to do our best based on what's in front of us, what the evidence is, what the law is. And so the populist move that judges be responsive to the majority misconstrues what the judicial role is in a democracy. But we've held firm in Canada, and I'm very proud of the legacy now of saying to these people, you just don't understand what judges do, and we held our ground, and we keep doing what we did in the 80s.
Well, Justice Abella, an hour, it's amazing. We've held 330 people captivated for the last hour with speakers. It's been a pleasure to spend some time with you. I do have one small last question, and it's related to the photographs in the background. You mentioned Fred Astaire, and at some point we should debate Fred or Gene Kelly as the greatest male dancers in the history of Hollywood, and we've had this discussion already, but we'll have to save that for another time. But you're a Fred Astaire fan, right?
I am a Fred Astaire. I'm an old movies fan. I'm a musicals fan. I'm a Broadway musicals fan. And I will say to all of you out there, I remember every time when I came to Ottawa and I told people I love Broadway musicals, quite a few of them said, oh my God, I only like symphonies and opera. I want you to know I have a classical piano degree as a graduate of the Royal Conservatory in music. I love classical music, but I am entitled to my brain soothers, and Broadway musicals and Fred Astaire and Gene Kelly and old movies do it for me. So don't be afraid to have the things that make your brain happy, even if they're not what people say sophisticated people should do.
Well, all of us here, we're so grateful you spent some time with us, and we're so grateful you've shared some thoughts with us, and we wish you a wonderful retirement from the court so you can spend a lot of time watching old movies, reading books, and hopefully getting back to spending time with your grandchildren and your family. And we know that, and we'll say you're always welcome here at the College of Law. Please come visit us anytime. We'd love to have you back in any capacity. And it's been a pleasure to spend some time with you, and you sharing your genuine warmth and your concern for the law it's really quite remarkable. So it's been my pleasure to meet you, and I hope we cross paths again soon.
I hope so too. It's been a wonderful experience, and I look forward to meeting your students one day.
Please do. Please
and
come
you.
back.
Thank you so much.
Nice
I'd love to.
Okay. Thank you. Bye-bye.
Okay. Thank you.
Thanks to everyone for attending today. It was a wonderful crowd, and we welcome you back. We have another Supreme Court Justice speaking in a month. Justice Sheila Martin will be delivering the Law Review of Saskatchewan lecture in about a month's time, and so please keep an eye out for other speakers' events. I'd like to thank Katie for organizing this, and Sarah and Dawn, and again, thanks to Justice Abella, and everybody have a wonderful afternoon, and take care of yourselves and stay warm. Thank you.
Thank you.
Thanks.
Bye. Thank you, Peter and Catherine. See you.